Hey, Dad. There's a lot of myths around when courts will hear from a judge that children can choose who they're going to live with. Bunch of that's bullshit. You really got to just get down to what's the actual code and what it actually says. And each state's going to be different, but in California, for example, the code reads that the court shall hear from a 14-year-old. That doesn't mean the 14-year-old is going to come in and testify. Judges will do everything they can to prevent that from happening. They don't want kids coming into court and sitting on a witness stand testifying against either parent. They may entertain the concept of having a minors counsel to go talk to the 14-year-old. They may have the 14-year-old write a letter. They may have the 14-year-old come in and they'll meet with the judge in chambers, like in the judge's room, with either a court reporter or a bailiff, somebody there to just make sure everybody's safe because judges don't want the kids feeling unsafe and they don't want to be accused of anything by either the parents, the parties, the judges, or the kid. So that's frequently why they'll come in with a court reporter to actually record everything that is then sealed unless there's an allegation that something happened. So the rule is this. Generally around 14, kids can start having a voice in this, but that voice is not determinative of everything. Some states it's a little bit younger. Generally 13 is like a cutoff. You got to check your own state and see what the code is, but you got to read it very carefully because it's not generally that they get to decide, because courts are generally like 13 and 14-year-olds are not smart enough to be making those decisions, but they are old enough to have a voice in what's going to affect them. If you want to learn more about this stuff, go check out dadslawschool.com, and remember, I think you're fucking awesome.